welcome to this video about the Law Commission. This forms part of law reform in the English legal system in AQA Paper 2. The specification for AQA requires you to know about law reform, including the work of the Law Commission. And that is 4 things: reform, repeal, codification and consolidation. 2 R's and 2 C's. It also requires you to know about the advantages and disadvantages of reform through the Law Commission. And it's quite interesting to look at the Law Commission website to see what they're working on at the moment. They work on a wide range of topics. In 2022, they were working on non-digital assets, including things like non-fungible tokens and what that's going to mean for the law. So they are a body that advises, they're independent politically, and they advise the government as to what might need to happen with changes to the law in England and Wales. So let's look at reform first. So the main law reform body is the Law Commission, and they are independent, and they were created by the Law Commissions Act of 1965. They're under a statutory duty to keep the law under review and to recommend reform where needed. The aims of the Commission are to keep the law fair, modern, simple and cost effective. And there are 5 commissioners who are highly qualified legal experts, and the chair has to be at least a High Court judge, so they have a lot of legal experience. So when they are dealing with reforming the Law Commission chooses an area to research, or they receive a referral from the government via the Lord Chancellor. If the Law Commission choose an area, it has to be approved by the Lord Chancellor, or it can just come directly from the Lord Chancellor. Then the Law Commission will research the law. They will consult relevant parties through a consultation paper. They'll produce a report, and then there will be the change in the law, the result. So we've got 2 R's, a C and another 2 R's there to help you to try and remember that. So let's have a look at an example, which is the Criminal Justice and Courts Act of 2015. So first of all, the government, via the Lord Chancellor, referred the matter of juror misconduct to the Law Commission in January 2012, following a number of cases, including Dallas, where somebody looked up information about a defendant whilst they were sitting on a jury, and then they told the information to their fellow jurors, which was potentially prejudicial. And the government were worried about the number of instances happening where jurors were looking up information online and wanted to review the law and see if it needed changing. So it asked the Law Commission to do that. So then the Law Commission, once they've got their referral, they start doing some research, and they look at a wide-ranging number of sources, including statute, common law cases and academic research. And in this case, they looked at the research conducted by Cheryl Thomas into whether juries are fair, and used that to inform their decisions. Her research included information like, in high-profile cases, 26% of jurors had seen information about the case and 12% had actively looked for it. And so that's the sort of thing they were looking at in their research. Then they carry out consultation, so this is the C in the middle of the R's. Consultation including, again, a lot of different people: the CPS, the Law Society, the Barristers Group, the Bar Association and other academics, and anyone can comment on these consultation papers, even members of the public. And then they will report recommending reform. And in this case, the result was the Criminal Justice and Courts Act of 2015, which amends the Juries Act 1974 to make it an offence for a juror to intentionally seek information. This took 3 years to come into force from the date of referral, so you can see that it is not a speedy process. Next, I'm going to look at repeal. So we've looked at reform, now we're going to look at repeal. The Law Commission tries to look at all the acts that are still on the statute book to make sure that they are still needed and to keep the law clear and accessible. So if laws have become obsolete, that means they're no longer needed, then they'll recommend that they be repealed by Parliament. Note it can't actually repeal the laws itself. It doesn't have the power to make or change law, the Law Commission. It just recommends changes. And it did that most recently in the Statute Law Repeals Act of 2013 that you can see on the screen here. And altogether, including all the statutes that were repealed in 2013 and previously, over 3,000 old statutes have been repealed. And this includes things like the rebuilding of St Paul's Act of 1696, which was brought into force after the Great Fire of London. And in 2013, that was repealed as it's no longer needed and it's just cluttering up the statute book. So next we'll look at codification, their work in codification. And this is where they look at all the law on a particular topic and again, quite wide-ranging, acts, case law and academic research. And they create a code that includes all of the law. And that means that codification can change and improve the law. And in fact, the Law Commission is still trying to look at a project about codifying the criminal law that's been ongoing for a number of years. By contrast, consolidation is where all the law on one subject that's already in existence is brought together under one act. And so it's different to codification because there are no changes to the law. So in the Sentencing Act 2020, it brought together about 1,300 pages of complex legislation from over 50 statutes, I think, to bring it into one act. But it didn't change the law. It didn't change any of the maximum sentences or anything like that. It just brought all of the law together into one act, the Sentencing Act of 2020. So it's a very good example of consolidation. So we said earlier that you would need to be able to evaluate the Law Commission, and if you're asked to evaluate, you need to try and include some advantages and disadvantages, but as we'll see later, you might be asked to just look at the advantages of the Law Commission. So let's look at the advantages first. Two-thirds of the Law Commission's recommendations are actually implemented, which shows that they do have a reasonable success rate. And one of their successes that we just looked at was the Sentencing Act of 2020. Another advantage of them is that they are legal experts. They have extensive legal experience, and the chair has to be at least a High Court judge, which shows that the people looking into the law and recommending changes are expert. They can consult widely, taking account of many viewpoints, and they're free from political pressure. And they help to keep the law clear. We saw that over 3,000 acts have been repealed. So when you're using advantages and disadvantages, try and give examples that support the point that you're making so that you can develop each point. Now we'll look at the disadvantages of the Law Commission. Obviously, if two-thirds of their recommendations are implemented, one-third are not implemented. A good example of this is the law on non-fatal offences. The Law Commission first recommended this was changed in 1993, and it still hasn't been done. So the flip side is that at least a third of what they do isn't taken into law. The government isn't obliged to consult the Law Commission at all, which is a disadvantage. But the Law Commission Act 2009 does require the Lord Chancellor to make a report annually to Parliament on the progress that they've made in implementing the Law Commission's suggestions. There's very little parliamentary time left for law reform. If you think about recent big issues over the years like Brexit and COVID, that has taken up a huge amount of parliamentary time, and there is little time left to look into law reform issues. And lastly, the work on reform can be slow. The 3 years that it took for juror misconduct to come into law was actually reasonably fast, but the work can be very slow. And when they tackle very large areas like the Sentencing Act, that does slow the process down. So the Law Commission could come up as a multiple choice question or as a 5 or a 7 mark question. This is an example of a multiple choice question that covers all of their areas. So the Law Commission's role includes codification of specific areas of law. Choose the best definition of codification. So if you want to have a look through and see if you can find the 2 R's and 2 C's in the answers. So the answer to this is A, integrating all relevant laws in a new Act of Parliament. And that is because codification, as you'll remember, takes into account a wider amount of material than just simply statute. And so A is the correct description. B is describing consolidation, where you simply put acts together. C is describing repeal, where you get rid of obsolete and old-fashioned laws. And D is where you review all the relevant law. That is part of the Law Commission's work on reform. And don't forget that the repeal and reform isn't done by the Law Commission themselves, they just make recommendations. So lastly, we'll just have a look at these questions. So these are questions that have been in the exam in paper 2 already. Explain 2 aspects of the work of the Law Commission, give an example of an area of law the Law Commission has looked at. That's a 5-mark question. And it requires 3 aspects. So you want the 2 aspects of the work and then the example. So I'd recommend setting that out in 3 paragraphs, making it nice and easy for the marker. 1 aspect of the work of the Law Commission is, a second aspect is, and then give an example of an area of law that they have looked at. We have looked at juror misconduct in this video, but there are lots of other examples that you might have looked at, like the case of Ahluwalia and the impact that had on the Coroners and Justice Act 2009 and the changes it made to the law on provocation following those sorts of cases. So you can use any example there that you know about. And the 2 aspects you would choose from the 2 R's and 2 C's, the reform, repeal, codification and consolidation. Choose 2 of those and describe them. And then the other question, which was asked in a question 11 at the end as a 7-mark part, is any of these parties may take the view that the rules of law which apply need reforming. Assess the role of the Law Commission in any reform process. So this is an assess question, so it's worth 7 marks. And you would need to have at least 2 advantages and a disadvantage with some evidence for that. If it was worded differently, if they wanted just advantages or just disadvantages, you need to read the question carefully to make sure that you know what they're asking for, and then try and give 3 advantages or 3 disadvantages. The most common mistake is to miss this part out altogether. So when you're making your plan for your 30-mark question, you need to make sure that you have included this in your plan so that you don't forget to put it in. There is a separate part of the specification dealing with influences on Parliament, which has not been examined yet, and that would include things like the media, political influences and pressure groups. So you need to make sure that you're familiar with that as well as the parliamentary lawmaking process, which is all in the same sort of topic area. So I hope that video has been useful. Thanks very much.